Order all right.
Court is resumed. You may be seated.
One second. Thank you.
Over the lunch hour, Your Honor, I was able to even be to shorten how much time I need, not because what I had to say wasn't important, but because my friends have already said it. So
And they reminded you.
they actually didn't, but looking at my notes, I reminded myself.
Okay, thank you.
I want to move to a point of deference and correctness are not oil and water. Now, Ontario Council proposed that where you see a reference to deference, there cannot be a correctness standard because correctness and deference are oil and water. So they would argue where at paragraph 308 of the Restool decision, you see the Supreme Court of Canada saying a degree of deference is warranted. The court should automatically be excluding any possibility for a correctness standard to apply. I have two responses to that. First, we should all recall how the Supreme Court of Canada dealt with the interpretation of the treaty. They ruled that ultimately, because of the constitutional nature of the inquiry and in the involvement of the honor of the Crown, a constitutional principle, the matter ultimately must be decided on a correctness standard. That's Restool paragraphs 103 and 119. And this correctness standard applies even though deference might be warranted in respect of the trial judge's particular expertise in findings of fact. Similarly, the nature of the question in this review or the portion of this action that we are now in a review of is a matter of constitutional compliance. Second point, in the judicial review process itself, affording a degree of deference was the turn of phrase used by the Supreme Court of Canada in Haida Nation within a correctness standard. So I'm just going to pause and repeat that. Where you have a normal judicial review, where that phraseology, a degree of deference is found, is when the Supreme Court of Canada in Haida Nation is talking about a correctness standard. And I think maybe what I can do is, if you go to tab 10, I just chose one of the many judicial review cases to make my point about a degree of deference is not inconsistent with correctness. And I just decided to choose a case called Catlow Dici. That's at Compendium tab 20, page 158 of the reply compendium, 2013 FC 458. Catlow Dici, spelt the way I pronounced it, K-A-T-L-O-D-E-E-C-H-E, First Nation. Now, I only use this case for illustrative purposes because it involved a judicial review of a minister's decision to grant an oil and gas exploration water license use. So there we have allowed the license holder to use water for oil and gas exploration. Now, at paragraph 54 of the decision, which is found at compendium page 168, the court is referring to Haida Nation and quotes from Haida Nation and says, the existence or extent of the duty to consult or accommodate is a legal question in the sense that it defines a legal duty. However, it is typically premised on an assessment of the facts. It follows that a degree of deference to the findings of the initial adjudicator may be appropriate. Now, of course, we're in judicial review here and we're talking about adjudicators, far different from, sorry, when I say here, I mean in the Capilodici case, far different from the case at bar. And the court in Haida Nation continues on, the need for deference and its degree will depend on the nature of the question the tribunal was addressing and the extent to which the facts were within the expertise of the tribunal. Should the government misconceive the seriousness of the claim or the impact of the infringement, this question of law would likely be judged on correctness. Where the government is correct on these matters and acts on the appropriate standard, its decision will be set aside only if the government's process is unreasonable. The focus, as discussed above, is not on the outcome, but on the process of consultation. Here, we are not just concerned with the process of the engagement session, which itself I say is substantive, not just procedural, but we are focused, you are focused on the outcome. Is the outcome constitutionally compliant? Now, Ontario's whole approach to interpreting its obligations flowing from the treaty actually offends, in my view and my understanding, what the Supreme Court of Canada has cautioned the Crown must not do. And I thought about this a bit and I realized that the Manitoba Métis Federation case from 2013 is not a bad example of this. So over on tab 21 of reply compendium, our oral reply compendium, you'll have the case, find the case of Manitoba Métis Federation versus Canada. It's at 2013 SCC 14. And I wanted to make specific reference to paragraph 76 and 77, which I've excerpted out. And at paragraph 76, towards the end of that first paragraph, Supreme Court of Canada says, a purposive approach to interpretation informed by the honor of the Crown applies no less to treaty obligations. Now, in the MMF case, that was a case there was a constitutional obligation that the Crown failed to honor. And what they failed to do was to diligently implement a promise in the Manitoba Act, something that was part of the constitutional compromise that led to the province of Manitoba. But they didn't do it in a diligent way. And paragraph 77 says, the jurisprudence illustrates that an honorable interpretation of an obligation cannot be a legalistic one that divorces the words from their purpose. So when the Supreme Court of Canada is talking about you can't divorce the words from their purpose, they're in effect saying you can't divorce interpretation from the implementation of the obligation and what, in effect, what is required to honor the obligation. Now, lest there be any mistake about it, Justice Rothstein in MMF at paragraph 163 said, hold on a sec here. Now there was an appeal from a judge. Justice Rothstein said at paragraph 163, while the majority does not do so explicitly, aspects of their review and use of the facts depart from the findings of fact made by the trial judge. However, at no point Do they show that the trial judge made any palpable and overriding error in reaching his conclusions? The reason for that is because the Supreme Court of Canada, recognizing the constitutional nature of the obligation, dealt with it, although they didn't say this, they dealt with it as a correctness standard without deference to the findings of fact of the lower court, even where the lower court had expertise in findings of fact. And we should not forget what the Supreme Court of Canada said in Restoule at paragraph 220. Maybe that could be pulled up. Although the honor of the crown is a powerful constitutional doctrine, it is not a cause of action itself. Rather, it speaks to how obligations that attract it must be fulfilled. So the constitutional doctrine defines how obligations must be fulfilled. Now, we say, therefore, that it is not possible to separate implementation and interpretation as easily as Canada suggests, or as Ontario suggests, excuse me. Now, not too long ago, the Federal Court of Appeal, in a case called Mikovic versus Canada, 2021 FCA 184, which is found at tab 22 of my reply compendium, and Makovic Corporation is Makivik Corporation, dealt with this issue more head on. The issue was standard of review of the interpretation of implementation of a modern day treaty. And at paragraph 80, the Federal Court of Appeal, and this is over on reply factum, my oral reply compendium, page 208. The Federal Court of Appeal says this: second, the standard of review that in my view applies is consistent with both what occurred and what was said in Nacho Nyakdun, NACHO space NYAK space DUN. There, the Supreme Court came to its own view on the treaty interpretation and compliance issues that arose without deference either to government or the First Nation parties. While the Supreme Court of Canada did not expressly address standard of review in its decision, both lower courts did. They're doing so, I'm leaving off the sites, they're doing so, says the Federal Court of Appeal, attracted no criticism from the Supreme Court. And at paragraph 81, the Federal Court says, as the Supreme Court of Canada stated in Nacho Nyakdun, modern treaties are intended to renew the relationship between Indigenous peoples and the Crown to one of equal partnership, referring to paragraph 33. The same could be said of this treaty. And the Federal Court of Appeal observes as following: deferring to one partner's views of the meaning of or compliance with the treaty would be inconsistent with the nature of that relationship. And that is a very handy way of saying where we are at in this particular case. Now, the case, the Federal Court of Appeal case, goes on to discuss that in a common judicial review where there are extricable findings of fact unrelated to the constitutional issues and within the tribunal's expertise under the assessment of evidence, in a normal judicial review, there would be deference. But we are not in that normal judicial review world. And I thought it would be useful to bring the court to that Makovic case because I think it summarizes nicely the importance of the relationship and why deference is not appropriate and why the standard should be correctness. I have the next section that the source of the Crown's discretion is the treaty, not the royal prerogative. And this has been dealt with already by my friends, so I can skip over many pages. Next, the role of this court in this stage 3. Now, my friends in oral submissions said that your role is as judicial review. Respectfully, the Supreme Court of Canada did not convert this action into a judicial review, and I want to take the court through what the Supreme Court of Canada did do. Firstly, if you look at paragraph 311 of the Restool decision, you see the disposition. And the disposition from the Supreme Court of Canada is to do two things. It provided specific declarations at paragraph 304, and it provided specific directions contained in 305 to 310. At paragraph 305, the Supreme Court of Canada makes the very express determination that the discretion is to determine an amount to compensate for past breaches. I want to emphasize that. We're not just there to determine judicial, determine what the annuities might have been, but we're to determine to compensate for past breaches. And at paragraph 307, the stage 3 trial, says the Supreme Court of Canada, is to be modified in accordance with these reasons. Now, when read as a whole, I feel relatively confident in telling the court that what the Supreme Court of Canada directed and decided was for this court to do the following. 1, decide whether the engagement process and the past compensation amount arrived at by the Crown's exercise of discretion are constitutionally compliant or not. Whatever standard of review is used, the review part of the stage 3 ends with a binary answer. Yes, they were both constitutionally compliant, or no, one or both of them were not. As paragraph 299 explains and makes expressly clear, the constitutional compliance is to A, ensure that the discretion is in accordance with the treaty obligation, and ensure that the discretion is consistent with the honor of the Crown. It's both. We focused very much in the last couple of weeks on the honor of the Crown, but I don't want the court to lose sight of the importance of compliance with the obligation itself. Then the Supreme Court of Canada at paragraph 309 tells the court what to do in respect of the 5 factors. And it says, in sitting in I'm not quoting, at 309, in sitting in judgment on the Crown's conduct and the exercise of the Crown's discretion, the court is to consider the following factors. Now, notably, the Supreme Court of Canada does not say that the court is bound to defer to how the Crown thinks the 5 factors are to be considered. No doubt, as paragraph 290 makes clear, careful attention to what the Crown's explanations are is warranted. And at paragraph 290, the Supreme Court of Canada tells the court, wait until the Crown has proposed the amount of compensation to redress the harms occasioned by its neglect. That is right from 290. I don't want to lose sight of those important words that we're trying to find redress for the harms occasioned by the neglect. And once the court has grappled with that proposed discretionary decision, the court decides, is that discretionary decision and the process used to get there, were they constitutionally compliant or not? Now, if the court decides that there has been constitutional compliance with both elements, the case ends. However, if the court decides that either the engagement process or the quantification of past compensation is not constitutionally compliant, then we are squarely back at the action part of the case. And you have been given the authority and instructed to ensure a just remedy, and you have been given wide latitude, both by the Restool decision and by Takuhikan, to craft an effective remedy of your choosing. Section 310 of Restool makes absolutely clear that the remedy can comprise an open-ended judicial assessment or quantification of damages for past breaches, or as paragraph 302 of Restool tells us, proceed with a court-calculated compensation award. Now, it's a trite observation, I suggest, that if we were simply on a judicial review and nothing more, the court does not, on quashing a decision on judicial review, have the authority to award damages. So whatever this modified action is, it's not a judicial review. It is a sui generis modification of the action, and I think best explained as a deferral of the court's usual role in a compensation trial to decide a threshold question first. Has there been constitutional compliance in a voluntary way? In effect, what the Supreme Court of Canada did was to craft a very unique remedy to give the Crown one last chance to come up with an acceptable range that the court would be satisfied is just and honorable and consistent with the treaty obligation. And if the Crowns miss the mark, they have to live with the risk of their choice. And the choice they have made in the engagement session and the choice they have made about the amount of that they are prepared to take, they have made that choice and they have accepted the risk of leaving the matter to be decided by the court if their proposed amount misses the mark, which we say it does. They were prepared to take that risk, and they should live with the consequences of that risk. Now, remedy. the court need not and should not remit the matter back, but should come up with a past compensation amount. Both crowns in oral submissions urged upon this court that, like a usual judicial review, the appropriate remedy should be just remitted back. Now, after listening to the Crown's oral submissions and seeing the way the Supreme Court of Canada's decision has been by them spliced into bits and pieces in an effort to support a desired result, there is all the more reason not to remit it back. Through this current stage 3 proceedings and in the engagement session, the court has the benefit of all the necessary evidence, all the necessary data, all the principles of quantification that it might need to set an amount for past compensation that is just, honorable, generous, and as the Supreme Court of Canada says, paragraph 295, is going to be substantial. Moreover, now that the Crowns have been given the opportunity to explain and justify their polycentric considerations that might bear upon quantification, the court is in a very good position to fairly take in those polycentric considerations, of which there is one, a logical connection to the just quantification, and in respect of which there is compellable, cogent evidence that the polycentric consideration should yield a specific, or tell you which way you should be going in terms of a specific amount. Now, I've already told you that we don't see any evidence of polycentric considerations weighing in this. There's no evidence. There's just an assertion of polycentric considerations. What we do say is there is a principled approach to arriving at a just past compensation amount that incorporates principled positions which one or both of the Crown emanations agreed with. And what this court might have observed is that when you take the best of what the Crown had from both of them, you come up very much to the proper position that the First Nations were prepared to live with. So a principled path yields something very close to the plaintiff's January 11th, 2025 offer. Now, I am not walking back from the reasonableness, conservativeness, and conciliatory nature of the approach set forth in our January 11th, 2025 letter. Rather, I'm just trying to point out that even if one adopts the principled approaches the Crowns were prepared to live with, we get to pretty much the same place. If you take those principles and use them with defensible inputs that are based on evidence that is reliable. Now, a more detailed example and explanation of how the Crown principled approach would work out is, I've got it set out in my reply compendium at tab 27, but I don't want to take you to there because it uses numbers as an example. And I want to stick with principles. First principle, Canada acknowledges that Hutchins' NCRR work should be favored. Adopt that approach. It's consistent with our approach. Now, how far towards Hutchins you go is up to you. I used a particular percentage in my example, but it doesn't matter. It's the principle I want you to think about. Now, however far you go to Hutchings, it should be on nominal amounts, not baked in bond rates. It should be somewhere between Bodway and Smart's 20 million and Hutchings 1 billion. Second, you have to come up with some sort of assessment of what the augmentations would have been in the past. And you can do that on a year by year, or you could do it globally, but it has to be done. Now, here, Canada proposed that one reasonable approach is to use 50-50. Well, as I said, you can use 50-50, but and that can be done year by year or globally. But a fair question, I think, for the court is, given Canada's acknowledgement that 50-50 could be a reasonable approach, what evidence do you have, given the vast Anishinaabe need, that it would not be at least 50% or should not be at least 50%? Is there polycentric evidence of polycentric concerns that would suggest that 50-50 is too much? Look for it. I'm going to suggest you're not going to find it. The next step would be to adopt Canada's approach on bring forward, which is a principled approach, which is actually the same as ours, which is that you have to choose a number that properly reflects the lost opportunity, the pecuniary loss, the harms. So choose a bring forward rate that is consistent with the evidentiary record and which factors in that lost opportunity suffered by the Anishinaabe in not having had the use of the funds over the years. As I said, Canada adopted this approach. Unfortunately, the bond rate does not make sense, is not supported by the evidence, and so some other rate for some other period should be chosen. You have lots.
Say that using the bond rate does not reflect Canada's rated position.
No. Using the bond rate, the principle is that the bring forward rate should reflect a rate that addresses lost opportunity, pecuniary loss. And I'm saying 5%, the bond rate, which is an average of 4.93%, it doesn't do that. The bond rate is Canada's cost of performance. Southwind tells us that's wrong. You've heard from my colleagues about why that's wrong. The proper bring forward rate is one that asks the question, what would the Anishinaabe have done with the money and what rate of return would they have gotten? So in principle, Canada is on side with us. They just use the wrong rate.
That's what I was asking you. So you say Canada, in proposing the bond rate, is not consistent with their
own principle. That's correct. Right. I apologize for not understanding the question, but I think we've got it. Next, we have a problem with indirect capture. Well, let's just add Ontario's principled position of 25% of NCRRs that you arrive at to recognize indirect capture. Now, to that, you could add an additional amount to recognize the intangible and non-pecuniary losses, as both crowns were prepared to do. Both crowns were prepared to do that. But you should not express it as a fixed number amount, but if you take what they did and express it as a percentage of the benefit calculation that they were prepared to live with, what they actually did, Canada raised it by 300 million, Ontario raised it by 225 million, and that's on a $3 billion amount. So they, in effect, said to the court, said to us, to recognize the intangibles, will bump it up by 17.5%. And I say, take them up on that. Add 17.5% to the benefits that the Crown captured, direct and indirect. And you're going to get something that's very close to the January 11th number of 35 billion. If you add a top up for Whitesand and Red Rock, including as part of the recognition for their unique incremental losses, the cost of a counsel fee that is to be assessed. If you do all of the above, what you're going to find, no matter what inputs you can reasonably find, is that you're going to be within what I would call a Goldilocks zone. Not too hot, not too cold, but just right. And by right, you could say just correct. You could say just reasonable, but just right. And notably, there could be within the range one or more right answers. But like the Goldilocks zone, everybody knows if it's too hot, not too hot, or not too cold. And that's where you need to get to. And thankfully, you have the evidence to get you there. I have a few closing remarks, and then I'm done in about 3 or 4 minutes. Under any standard of review, the engagement process was not constitutionally compliant. Under any standard of review, the past compensation amount is not constitutionally compliant. Now, a judicial, if this was in Takuhikan, if the amount was significantly larger, a judicial action to quantify losses likely would have been ordered. I think that's fair, because when they talk about proportionality, they say it's not, we don't need to actually send it back to a judge to figure out what the loss is. Doesn't mean they're guessing, doesn't mean that they were wrong in that case, but let's suppose that because of the large amounts in this case, it would need to be determined by a court. Well, we've not only been through a detailed trial examining the very issues that the court needs to make the compensation award, the court has the evidence, or we say the lack of evidence, of genuine polycentric concerns that might temper the payment to be made. The Anishinaabe, the RST Anishinaabe have waited 175 years for justice. Whitesand and Red Rock have fought for 25 years of those 175 years to secure recognition and vindication of the rights for all RST nations. This court has the tools to make a just award now, and it should make a just award now. Unless the court has any questions for me, that's my submissions on closing remarks.
No questions. Thank you very much. I believe that's it.
I believe that's it in terms of reply, yes. Thank you.
So we have come to the end of this review, and of course, I will take this under reserve and will work on it as diligently as I can. Before I leave, I sit here before all of you and say thank you. And let me start with the public gallery. I have sat a long time as a judge in many cases that have various degrees of community interest, but rarely do the members of the public sustain their interest by attending in such a respectful way. And it makes me believe in a system where you believe that all that is important for the court to hear has been heard, and you have heard every argument, you have heard every submission, and you have heard every question that I have asked. And I take that as a serious show that you have a confidence, not in me, not in this case, but in the bigger institution. And that is very heartwarming. So I am very grateful to all of you. Thank you. And counsel, I have much gratitude to you for all that you have contributed to these proceedings over the years, over the weeks and the months that preceded this case. As we all know, much work is done before we get into this courtroom, and all along the way, I have appreciated your contributions. My thanks. So we're finished in this courtroom. Mr. Bass, is there anything?
So I think we finished a little bit earlier than we were anticipating. So we might need a little bit of time just to discuss and get everything in order. So perhaps if we want to stand down now and reconvene, what did I say, in 15 minutes?
Well, I'm sure we all have lots of packing up. So, but we'll come back on record in 15 minutes.
Sure.
Very good. Thank you.
Court is on recess until recalled. Court is now resumed. You may be seated.
Yes. Thank you for the court's indulgence. So we're prepared to proceed now with a procession of the staffs back to courtroom 101, led by Justice of the Peace Woods. And as we do so, Elder Charlene from Pays Plat First Nation will be drumming the traveling song for us as the procession leaves the courtroom.
Thank you.
And so with that, I turn it over to Justice of the Peace Woods.
Bonjour. Justice of Peace Woods is one of my roles. I also have carried some other roles, father and all that kind of stuff. The way you didn't know it, there's pause for the Kuching Tonchi. Manatu Aki Tonchi. Big which November, he's again big which Bobanum, Shawanam, Leonam Kiwi. Big which Mishomas Anonic, Mishomas, Inokamis Anonic, Benoshuk. Big which November, he's again. Which for the process here today. So all I really said is my real name is Northern Wind. I come from a place where the lake empties. It's in Couchiching First Nation in the Treaty 3 territory. I also am the carrier of the staff. And what I just basically said in Ojibwe, Anishinaabe, Owin, is I thanked the spirits for participating here today, for participating in these discussions over the last few days that have occurred. We think about, in terms of when we carry these things and we carry our lives, we think about those ancestors that came before us. We think about our families and our communities and the children that we have here today. We also think about those that are about to come after us. That's how we conduct ourselves. So I understand there was a ceremony that started this process. There's been a sacred fire that's been carried and kept over the duration of this. We are now closing that part off. But we had also, there was a smudge that happened before when we started this process. We don't need this smudge after, the way I was taught. The way I'm also taught is there's no two ceremonies that are ever the same, and that everybody who participates in those ceremonies is everybody who's supposed to be there. And in regards to why we don't need this smudge when we leave, We've already done that. We've already cleansed our hearts. We've already cleansed our minds and our spirits. The challenge that we each all carry here now today as being part of these discussions is to go away with Deb Wayland, Deb Kendon, to go away with the knowledge and with the truth, and to carry that with a good heart, and to try to figure out what that means for each and every one of us, whatever our roles are. So when we leave here, we'll hear the traveling song, a traveling song that sends us on a good way with a good heart, and we proceed with that. It's not necessarily we need to recleanse after this process, so to speak, because it was a process, and I heard Her Honor speak to how, if I may, how empowering it was to hear her speak, and how personally I have so much reverence for our system. And I come at it from a very unique, and our justice system in particular, because I carry that with me and trying to figure out what that means as a Anishinaabe, who also subscribe to our natural laws, which we also have. And if you heard what I said in the prayer and what I spoke about in our language, it adheres to those natural laws. Those words are intrinsic in what that means. And it really is about taking care of ourselves, what our ancestors wanted for us, Mother Earth, Spirit Earth, our families and our children and those that are coming after us. So I wish everybody well, take good care, travel safe. We will carry these staffs back out into where they belong in this court. I've been blessed to carry this legal staff that's here in the courtroom. I've been taught the teachings from his then worship, Donio. He's now Elder Donio for one of the communities. And he shared the teachings with me, and I just want to share this with you folks. Talked about this staff is about peace, and it doesn't go into places of conflict. The court, although we can live and work in an adversarial system, it doesn't mean we can't work together. If I understand the principles of the court system, it's about to get at it's designed to get at the truth. And we can find the truth in peaceful ways. And I believe that's exactly what our honor was advising us. You which?
So I'll follow you.
Ask you folks, we will come out with the staff. You'll stand in the doorway and you can just follow out the door. Your honor will follow us. And these staffs are also about, best way to explain it in English is it's protection. And each one of these feathers has a story. And there's a whole story here of the clan system and the territory here on this staff when it was gifted to the court. And when it was gifted to understand, and I talked a little bit about natural laws, these clan systems and how they function and help us learn about our roles and responsibilities here on Mother Earth. And it's not only the clan system, but it's also Mother Earth and how we relate to nature and each other. Well,